Okay, welcome everybody to today's meeting at the Area Planning Committee. I think everybody here knows how this all works, but for the benefit of those at home, my name's Councillor Andrew Hollier. I'm the chair of the committee and I'm joined today by the other 6 committee members, sort of seated on the left and the right hand sides. And then we've got Gareth Arnold, who's the council development manager, and sorry, Sarah White, who's the democracy officer, helping us with the minutes and making sure we don't stray too far off track. We'll start with a presentation from Gareth on the single item we've got today, followed by an opportunity for public speakers to have their say. We'll come back to Gareth for any questions following that, and then after that we'll debate and come to a decision. So I think we can move straight on to the agenda. First item is declarations of interest, if I've got any from anyone. No, can't see any. I should also just note that we've got 2 substitutions today as well. Councillor de Gorn, who's substituting for Councillor Craghill, and Councillor Wardby, who's substituting for Councillor Coolwick. Move on then to item 2, which is to approve and sign the minutes of the last meeting, or not the last meeting, the meeting presumably before the last meeting, which was the 30th of March. If anybody's got any points they'd like to raise, Councillor Crawshaw.
Thanks, Chair. I think on page 12, at minute 45F, I think we should just make it clear that Councillors Perrott and Webb left the meeting before the vote took place. It does say at the start that that's what they intend to do in their declarations of interest, but the minutes don't record the time at which they left the meeting. And because it then says a named vote was taken and all members voted in favour of that proposal, I think it's just important that we make it absolutely crystal clear that Councillors Webb and Perrott were not part of that vote.
Okay, I'm sure we're all happy with that. Otherwise, happy for me to sign the minutes? Yep. Do so later. Item 3, so we've got no speakers under the general public participation remit of the committee, so we can move straight on to the plans list. And the only item we've got today is 45 Lea Way, Huntington. Gareth, if you're able to.
Sure, thank you, Chair. This is a planning application which involves the demolition of number 45 Lea Way, the creation of an access road, and the construction of 5 detached houses in the land to the rear. I've got a PowerPoint presentation on the screen. So this property is number 45, attached to number 47. The trees you can see here are covered by a group tree preservation order. Relatively recent development to the north by Joseph Rowntree Housing Trust. This is the layout. So the new road access from Lea Way, visitors parking space, passing place. Then there are 3 2-bedroom houses and 2 4-bedroom houses, one with a detached garage. The proposal does result in the loss of 2 of the trees covered by a tree preservation order. Site elevation from the north. So this is from the access road on the north side of the site. So you can see these 2-bedroom houses here, a single bedroom and bathroom in the first floor, but most of the accommodation on the ground floor. It's the flank, the exposed flank of number 47, which becomes a detached bungalow. The front elevation of the 2 4-bedroom houses. And here's the Joseph Rowntree Trust site to the north. That's the elevation from the open land to the south. So the rear of these 2-bedroom houses and the side of the southernmost 4-bed. More detailed elevations for plot 1. And its floor plans showing the bedroom and the bathroom in the first floor, further bedroom on the ground floor. Plots 2 and 3 are very similar. Some difference in the internal layout, but still a 2-bedroom house with 1 bedroom at first floor level. It's the elevation of plot 4, and its floor plan. Plot 5, which has an integral garage as well as 2 parking spaces to the front, and its floor plan. Photographs of the site. So this is Lea Way, from Lea Way, number 43, number 45 to be demolished, number 47, and the trees subject to the tree preservation order to the rear. Site from the south. That building there is a large double garage, which is within the application site. There was, until recent times, a boundary formed by hedges and trees along here, but that has been taken out. And then from the eastern edge of the site, looking back towards the bungalow at 45, its neighbour at 47, the detached garage there, and the trees along the boundary. So that's the end of the presentation. There is an update in front of members. It's a printed update. We've received an additional representation from the occupiers of 47 Lea Way. That's largely regarding matters which are within the bounds of the Party Wall Act. There is also a correction to paragraphs 5.35 and 6.21 of the report. That's clarifying that there are 2 trees to be removed, 2 protected trees to be removed. The sycamore, known as T1, in addition to the willow T3, which is the one that's specified in the report. There are some alterations to conditions. There's a new condition regarding requiring full details of the proposed works to the newly exposed flank of 47 Lea Way. The condition below is also a new condition. It incorrectly states condition 7. It won't be condition 7. There is on, let's go back. As you can see, that dotted line there is like a post and rail fence to prevent, prevent car access, people using it as overflow parking under the canopies of those trees. So the new condition is requires the details of that protective barrier and its retention. And then consequently, condition 5 has been reworded because that requirement was originally within condition 5, and it's just to make it clear that it's two separate requirements. And then at the bottom there is an additional informative just to draw the applicant's attention to the provisions of the Party Wall Act.
Thank you. I'll just ask if members have got any questions. I've got one to start with, and then I'll come to Councillor Fisher. And then it was just in terms, Gareth, you said something about removing the hedges and the trees. Did they form the boundary? As I understand it, in the old plan, the green belts didn't include the southern field. But in the proposed sort of new plan, it does include that field up to the southern boundary with this site. Did those trees and hedges form the sort of boundary that in effect produced that line for the green belt?
They formed, they would have formed the boundary to the site. That's right. Members turn to page 39 of the agenda, which is where we've got the map of the area. So the land to the south, so it's greyed out the application site. The land to the south in the 2005 plan, as Councillor Hollier says, was shown as open space rather than green belts. Green belts started on to the east of that line that runs north-south. In the current plan, the green belt starts south of the application site. It would have been a boundary that was used to denote the change from a residential garden to the greenbelt site. It is a garden rather than farmland. The land to the south is farmland. The fact that they've removed the boundary which formed that enclosure, I wouldn't say would be compelling in saying that changes the status of the land, personally.
Just to follow that up, so the land is effectively out of the green belt because it's a garden, rather than because when you look at the sort of photographs, it'd be difficult to, I guess, discern on the ground where that boundary would be, because it all looks like one single piece of land. But those, I guess, hedges and trees did form a barrier that would have made that more robust, I guess, as a designation outside the green belts. I guess that's going through a consultation at the moment as well. I don't know, are you aware of any sort of dispute over that line, or is it generally, I guess it wasn't in the green belt before, it's proposed to still not be in the green belt. I don't know, is there any sort of dispute over that that's being consulted on at the moment, or is it essentially, generally sort of well recognised boundary? Or?
I'm not aware that this area it forms part of the consultation. So there are various parts of the inner boundary and boundaries in the villages, for example, where we've looked again at the greenbelt boundary, clarified it in some cases, suggested modifications. I'm not aware; it's not been drawn to my attention that this was one of those parts of the boundary. It wouldn't have been excluded from the green belt because it being necessarily because it being a garden, but that was a factor, that there was it was a residential garden similar to those properties up. So the residential scheme immediately to the north was formerly residential garden, and then above that you can see those large gardens, part of Lea Way. So it's that sort of it's that residential character of the land, as well as that hard boundary along the eastern side, and the fact that the land to the south is farmland, which led which would have led to it being considered to be land within the urban area rather than greenbelt land.
Okay, thank you. Councillor Fisher?
Thank you. I'm well aware the Party Wall Act is more a matter of civil law than a matter of planning law, but I am concerned about the possibility that that wall was not built to the same standards as a normal external wall. Normally, when you have the internal walls between two semis, they don't, for example, have a cavity. They wouldn't have any insulation in them. Do building regulations, you may know this, building regulations insist on that wall being reconstructed as a cavity wall with property cavity wall insulation to protect the thermal efficiency of number 47?
Yeah, that's my understanding. They will require building regulations consent, and it will be required to build to modern standards, contemporary standards.
Just indulge a supplementary on that. Condition 12. I suppose my first question was whether no developments above foundation level would include the demolition itself. Presumably demolition is development. And then my second question was just to confirm which property this is talking about. The approved residential from externally. I'm assuming it means 47.
No, this condition relates to the new build, the 5 new build properties. So this is because of the proximity to the Portakabin site to the south.
Okay.
Which obviously is it's a general industrial site and does sometimes work late hours. So that's the intention, to protect the new residential from that noise source.
Okay, that makes more sense. Got any more questions? Councillor Webb?
Thank you, Chair. So I've got a question about paragraph 5.24. A small pump is proposed in the ground close to the rear garden at number 43. This is related to removing foul sewerage from the site. Is that common? Is that something, and why has that been decided upon? That's a good idea.
It's not uncommon, because it's there are foul and surface water pumping stations all over the place, really.
Yeah.
It's normally because there isn't the fall in the land to get so that gravity will do the job. So it needs to be pumped to the foul sewer in Lea Way, which is some way from this site. So I think it's the drawing show it as a rising main, which suggests there's some upward slope that this needs. So it needs the pump to get it up that slope.
I've just got another question. It's about it's the neighbour notifications and publicity. Someone has said the access to the site does not meet 5.5 metre highways requirement. It's inadequate for fire vehicles. Later on, I think the emergency services have said it is adequate because it's not the 5.5 metre width, I don't think. But could you just clarify,
No.
does it have to be 5.5 metres or what's going on there?
Well, manual for streets gives a range, and it's all dependent on what your street serves. So it suggests 4.8 is acceptable width. It's at the lower end of acceptable widths for minor side street junctions. So I would say 5 house development is pretty minor, and 4.8 you can easily pass 2 cars. Emergency vehicles wouldn't find a problem with that either. Lea Way itself is only about 5 metres wide, I think.
Thanks, Chair. Just a quick point of clarification. Again, it's on the neighbour notification and the objections that have been raised, and it's just the last one. So It says the scheme encroaches onto farmland to the south and a public right of way to the east. I think you've already covered the issue about whether or not it's farmland by virtue of the fact it's residential garden. But in terms of the public right of way, could you just confirm that that's been double checked and that it either does or doesn't encroach onto a public right of way?
There's nothing on the definitive map which shows that there's a public right of way. That doesn't mean it's not. It just hasn't been identified as such. Again, if you go back to page 39, right at the bottom, you'll see, right at the bottom of the page, you'll see number 63 Lea Way, and there's an access going to number 106, and then a track into the field. There's a 5-bar gate there, which according to the case officer has a sign on it saying no public access. There's also a track running north-south at the bottom, and earlier ordnance survey maps seem to show that track joining up with what looks like it's a track behind those gardens. Obviously, that doesn't mean it's a public right of way either. That could just be a farm track. So we don't have anything that suggests, there's nothing on the ground that suggests there is a well-used or even a used path through that back garden alongside the hedgerow.
Councillor Webb.
Apologies, Chair, just forgot my final question. It's more of again, another, is this common question. On 6.2, we're talking about root protection and a prescribed construction method that is more likely to protect roots, but it is not without potential risk to the trees. I was just wondering if you could elaborate a little bit more about potential risk. Is this a common practice and does it result in percentage of tree loss or not?
I think this is a comment from, or stems from a comment from the landscape architect. So when we can't deny that the building work, the construction of that access, construction vehicles going in and out of the site are within the root protection area and in relatively close proximity to some of the trees, especially tree, can't read that, T6, that's easier, isn't it, that one, which is close to the turning head. So the point that's being made is if you do everything in accordance with the tree protection conditions, then that should be enough to protect those trees. But human error, setting out error, surveying error could lead to issues. But apart from monitoring and trusting the people to do the job that the condition requires them to do, there's little else you can do and allow development in this site.
Councillor Crawshaw.
Thanks, Chair. I just wanted to return to the issue around the Party Wall Act. And I think, obviously, we need to be clear as a committee the things that are within our gift and not within our gift. And my understanding is, we can make a planning decision and then there needs to be some work done around the Party Wall Act and permission and what have you. But I was just sort of reflecting on Councillor Fisher's point around the requirement to insulate potentially and to build that what will become an external wall to building regs. And presumably that will mean that wall will need to become quite a lot wider, but the boundary of the property at number 47, the one that's retained, will presumably, the boundary will go down the line that divides the two properties, if you see what I mean. And so what I'm mindful of is if they need to put 6 inches or 8 inches of insulation, extra width on the side of the property, that won't be within their own boundary, presumably, or it would have to go on the inside wall, in which case it would reduce the living space on the inside. I realise that this is kind of not planning in a sense, because that would be covered by the Party Wall Act, but is that a correct understanding of what might have to happen? And is that something which could prevent the development going ahead anyway, even if planning permission was granted?
I think it's probably a detail that we wouldn't get involved in as a part of the planning process. It needs to be sorted out between the applicant and the adjacent, between the two landowners, and whether that means they change the boundary so that the whole of that new flank wall is within the ownership of number 47, which I assume that they will do. Then that's not really something that we would get involved in. The Party Wall Act gives a mechanism for these issues to be resolved.
I was going to say the plans don't seem to indicate that the line is moving out, but maybe this is a question for the agent who would do our.
No, they don't. But well, yes, the agent could help me out of this hole. I'm not sure that the width of a drawn line on a plan is necessarily reflective. For all I know, that could be drawn along the line of the possible, whether it's shared or whether it's half and half owned. I don't know.
Yeah,
just a shared wall. Then
if I may just supplementary. So, and just for my kind of complete clarity, because Party Wall Act is not something I particularly know a lot about. If an agreement was not reached through the Party Wall Act, because my basic understanding of it is that, you know, if you have a shared wall, you have to have an agreement between the two sides for work to go ahead on it. If an agreement was not reached, is the Party Wall Act something that would be sufficiently robust to prevent a demolition? What we don't want to see happen is number 45 get demolished and leave number 47 exposed, I suppose, is ultimately what we're driving at.
The Party Wall Act is designed to facilitate these things to go ahead, and it has dispute resolution. So the whole idea of it is you can't have a situation where one side doesn't agree to the works being undertaken, and it allows for the employment of third-party surveyors to come to a solution. That's the idea of it. Yeah.
Thank you. That's helpful.
Okay, thank you. Any further questions? Can't see any, so I think we're able then to move on to our public speakers. First public speaker we've got is Councillor Keith Orrell, who's speaking in opposition to the application, and he's the ward councillor. Members will see as well, you've got a sheet on your table which is from the applicant, and that's just to aid us. Appreciate last time it was quite difficult to hear what people were saying. So that's effectively a copy of the applicant's speech, just to follow along if we do struggle to hear what he's saying. But I will say to sort of both Councillor Orrell and Mark Andrews, who's the agent speaking on behalf of the applicant, that we do normally give 3 minutes, but it would be good if you could speak slowly and clearly, and so we won't be too strict on that 3 minutes, just to try and facilitate it coming across as sort of clearly as possible. But Councillor Orrell, if you can hear me.
Yes, I hear you.
Thank you. Yep, so if you're able to start in your own time.
Thank you. Good afternoon, everybody. Please stop me if you can't hear me. First, I want to express my concern for the residents at number 47. And thank you to all the members who put their questions about that. Like Councillor Crawshaw, I'm not that familiar with the Party Wall Acts, but it does seem to give little protection to residents in this situation, and it possibly landing them with costs that they didn't expect or cater for. It does not seem an equitable situation. As Gareth has said, from what I read, residents have to agree to something at the end, even if they don't want it. In 30 years as a councillor, I've never known this before. And I would hope that our council would support a resident in this situation. Moving on, major rationale for the development is the comparison to Leafield Court, which received planning permission in 2007. However, much has changed in Huntington since then. Since 2007, there have been 3 housing developments, the Vanguard Shopping Park, and now the Stadium Complex. All these developments have added to the strains on our infrastructure. More significantly, however, for this application is the allocation to the land to the east of Lea Way in the local plan, ST8 in the local plan, for nearly 1,000 houses. This land was designated as Green Belt when Leafield Court application was approved, so the loss of that area of green land would not have been considered critical to the local area. The ST8 proposal changes that scenario and would mean that Huntington and the Lea Way area in particular will be losing a large area of what is currently green land close to this proposal. It's also worth noting that Huntington is a very tightly developed area with very little green space. It's therefore important to retain the green land we have, especially near to where a large housing development is proposed. Local residents have detailed a number of concerns: traffic issues, impact on nearby residents, sewerage, as Councillor Webb referred to, Huntington's high water table, and the impact on wildlife and the impact on trees. Some of these issues are dealt with in the report, but there continues to be concerns about the impact on trees as a result of the development. You will see from the report that trees were felled before the application was submitted. It doesn't inspire confidence in relation to the existing trees and hedges that the report says will be protected. The report gives no indication of how policies CC1 and CC2 are to be achieved to comply with condition 14. As with the details of the protection of trees and hedges, this is not encouraging. Chair, this land is not allocated for development in the local plan. It's unallocated. As it is a back garden, this would not have been considered to need greenbelt protection. Until the local plan is examined and agreed by government, it will be premature to approve development of this land. As I have detailed, Huntington already has had and will have considerable housing development in the future. It is not necessary to use yet more green land. Thank you, Chair.
Thank you. And if you could just hang on, and I'll just ask if the committee have got any questions. I can't see any, so I'll thank you, Councillor Orwell, for your time this evening, and you should be able to continue watching on the Council's YouTube channel, so thank you very much. Move on then to Mark Andrews, who's the agent speaking on behalf of the applicant. And if you're able to hear me, Mr. Andrews.
Yes, hi, I can hear you.
Yeah, and you should have heard me say Normally we give speakers 3 minutes, but we'll try and be a bit sort of relaxed on that. If you're able to speak sort of slowly and clearly, that would be appreciated. But if you'd like to make a start in your own time.
Yes, thank you. Yep. Good afternoon, Chair and members of the committee. My name is Mark Andrews, architect at Vincent & Brown, the agent for this application, and thank you for the opportunity to speak in support of this development today. The application being considered has been through an extensive process of consultation and is substantially different to the scheme that was originally submitted. The scheme is developed through an iterative process of discussions with consultees and planning officers that have shaped its layout, scale and design. The site is located within development limits and the proposals are comparable, though smaller in scale, to the recently constructed Joseph Rowntree housing development located just to the north. The scheme before the committee today is, we believe, a well-balanced residential development of 5 dwellings organised around an attractive shared landscaped area. The development offers a mix of dwelling types, including 3 2-bed bungalow properties and 2 larger 4-bed properties at the end of the site. The design of the properties is modern in appearance, using a mixture of brick and timber cladding that reflects the local context. There are a number of concerns raised with the original scheme, and whilst the planning report notes that these have been addressed satisfactorily, I would just like to touch on some of these points, including on scale and layout, access and ecology. With regards to scale and layout, the properties along the southern edge of the site have been reduced in scale to bungalows and their footprints moved closer to the southern boundary, allowing for ample clearance from the root protection areas of the trees to the north. Accordingly, the external amenity space for each of these dwellings is organised around the sides of and between each property. The density of this development is therefore comparatively low due to the amount of open space retained on the site. The layout of the access road into the site was agreed with York City Council Highways, with parking numbers in excess of council standards and vehicle movements tracked. The proposed nodic method of construction for the access road will minimise the impact on the root protection areas of the TPO trees to the north. The demolition of the existing property at number 45 to create the new access for the development and the proposed treatment of the gable wall is detailed on the submitted drawings. These works will be carried out with sensitivity to the adjacent property, an external wall instated in accordance with the building regulations and controlled through the Party Wall Act. The proposals have incorporated a number of measures to enhance the biodiversity on site, including the creation of a wildflower area within the shared open amenity space and significant additional tree and hedgerow planting around the site. Now, whilst the site has presented its challenges to development, we believe the scheme addresses them effectively, and our client is now in a position to bring forward an attractive residential development with a mix of house types, including bungalows, that are suitable for this context and the local market. I will commend this proposal to the committee, and I'm happy to answer any questions that you may have.
Thank you. I'll just ask if the committee have got any questions. Councillor Crawshaw.
Thanks, Chair, and thanks for that, Mr. Andrews. You possibly heard the questions that we were asking around the shared wall of number 45 and number 47, and the issue around sufficiently insulating what will become an external wall and the potential for that to require a boundary adjustment. I just wondered what your thoughts were on that and whether or not they were things that you'd considered already, whether or not you would be happy to extend the boundary of the remaining bungalow to make sure that any works that are needed on that shared wall can be undertaken without impacting at all on the amenity space of the remaining building.
Yes, so as I mentioned, the works to that wall would be controlled through the Party Wall Act. I mean, the purpose of the Party Wall Act is to ensure that the adjoining owners don't suffer loss or damage to their property as a result of these proposed works. So a new external wall would be instated, which would meet with building regulations as an external wall. And I would expect that, yes, the boundary would have to be adjusted in order to take account for the enlarged width of that wall.
Thank you.
Thank you. Any further questions from the committee? Can't see any at this point, so I'll thank you, Mr. Andrews, for your time this evening. And obviously, your comments will be taken into account as we make the decision later. Thank you. Okay, then, have the committee got any further questions for Gareth or officers? Councillor Fisher.
Yes, concerning condition 5 on page 28, should be mindful to approve assessment development shall not be until been submitted and approved landscaping scheme. And it also says the scheme should be implemented for 6 months, and any trees or hedgerows or protected barriers on the whole application site, any plants outside private gardens, which thereafter in research the agency shall replace the next planting season. Now, there is no time limit on that. Does that mean that applies in perpetuity? Because normally we get a 6 months commission. Now, that means it's in perpetuity. I've been very pleased. Councillor Waters and I bang on about this, particularly at the meeting. The other issue is, of course, if it's going to be for a perpetual requirement, who shows the responsibility for that replanting? Would it be the actual households through some kind of common agreement, or would it be the actual original developers of the site?
It would be in perpetuity, but the wording, actually, this is a reworded condition on the update. So it would fall to whoever the landowner is in terms of trees and hedgerows. So it's written so that the local authority doesn't have to or try to exercise control over people's garden planting, and that is not a hedge or a tree, but it would cover any planting in that area on the northern boundary under the protected trees that I pointed out originally, and it would fall to whoever the landowner was to replace trees and hedgerows should they be removed.
Councillor Webb.
Cheers. So my question is about the road that the house is going to sit on. I presume they'll just be owned by the person who develops the land, or is there a plan for it to be adopted, or is that not something that we can? Yes, so the cars drive on.
I'm not aware of that. I'm not aware whether it's planned to be adopted or not. There's no reason why it shouldn't be in the access, certainly at the access end of it, but that's not a detail that's been shared with us.
Would that be something we could, I don't know, put as an informative of this is something we need to discuss? Even I don't know.
It's generally something that's discussed between the highways team and the developer, if the developer offers it up for adoption. It will be built, ordinarily will be built for to an adopted standard condition. Well, if they build it to an adopted standard, then it could be offered up for adoption. The planning process on a site this size probably wouldn't normally get involved at that level of detail.
Okay, thanks.
But there is a requirement, certainly at the end where it meets Lea Way, to ensure it is built to an acceptable standard of condition number. Yeah, condition number 7 requires the junction to be built to a standard to be approved by the authority.
Councillor Portion.
Thanks, Chair. I'm just looking at in the update in condition 27. So we heard the applicant saying that they would expect that the boundary may need to be adjusted to take account of the bringing the internal wall up to standard as an external wall. I'm just wondering whether it would be reasonable for us to add something to that condition 27, just to make that explicitly clear that if this was to be approved, there's an expectation that as well as works being completed in accordance with the approved details, any necessary boundary adjustments are made to accommodate said works, or something along those lines. And whether or not that's something that we could do.
I think it's outside of the scope of what we're here to do. It's a detail. Land ownership isn't a planning issue really, and it's a detail for them to sort out separately.
Okay.
My view on that.
Is it something that's perhaps an informative? I'm just wanting to make sure that we're clear, because that's, to my mind, with this application, there's two different aspects to it. There's the should the land be built on, you know, in terms of the open space or otherwise, and then there's this issue around the demolition of half of a semi-detached bungalow, which I think we're all saying none of us have ever come across previously. So it's just wanting to make sure that if the application was approved, it's as robust as possible to make sure that the remaining property and the people in that property, more importantly, are protected as much as we possibly can.
Yeah, I don't think that the planning process can't do that, because we wouldn't have the enforcement powers to require them to change the boundary, or require them to transfer land to the adjacent property. I think it just has to be covered by we have to rely on the other legal mechanisms, the Party Wall Act, the private agreement between the two parties, and then in terms of its construction, then the authority has its input as the approving authority under the building regulations. But we certainly have no powers to compel any changes in ownership.
Thank you.
Any further questions from the committee? Councillor de Gore?
Just following on that particular point, would the Party Wall Act also govern reasonable access for the owner to carry out maintenance work? You know, obviously, normally the property has an area around it which it can get access to maintain that gable wall, but would the Party Wall Act cover that as well? Is that something for the owner to ask about?
If it became if the whole of that flank wall became the ownership of number 47, which I assume we will do, then there are other access rights which allow you to go on to adjacent land in order to make reasonable maintenance access.
Okay.
Can't remember the name of the act, but there is a provision.
Legislation covers that. Okay.
And so I've turned off the screen now, but you'll recall it's a bit of it's a landscaped area. It wouldn't ordinarily impose any impediment to going around there and putting a ladder up or putting scaffolding.
Thank you. And the other question I've got is actually sort of at least partially answered by the update here. Note it says that there are 2 trees which they expect likely to be removed, but states that native trees will be planted within the same location to replace those lost trees. Is that conditioned somewhere in a new condition? Because you just stated that as an update.
It's shown on the landscape plan, and it would be covered by the landscape conditions, so they have to submit details of what's going in there. And then those replacement trees would be covered by the tree preservation order in the same way.
Thank you.
Any further questions? Can't see any, so if we're happy then to move into debate and give somebody to start us off. Councillor Way.
Thank you, Chair. I can understand that this will be incredibly difficult for number 47. But I think we have to, well, it's not within our gift to really not trust the Party Wall Act. We have to assume that that is going to do what it needs to do. And then actually, it provides protection for that household before anything can take place, and that's got to be very important. I would suggest that this is, well, it is clearly not greenbelt land. My earlier concerns about the trees and the loss of the trees or the damage to the roots, I think there is mitigating factors there. And I think we have to take this for what it is, and it is a number of family houses, which is something that we've gone on a lot about in recent time. It's low density, it's a sustainable development in an area where there are facilities nearby. Personally, I think I can see that this is, for me, the only thing that I'm reticent about is the Party Wall Act, but actually that is, as Gareth has said, is not really part of planning. So for me, reluctantly, I would happily move the officer's recommendation to approve, as we've discussed this evening.
Anybody willing to second that? Councillor Crawshaw.
Thanks, Chair. I think I would agree with most of what, well, all of what Councillor Webb has said. I think I would also draw committee's attention to paragraph 5.10, which states that paragraph 68 of the NPPF requires local planning authorities to support the development of windfall housing sites, particularly within existing settlements. We've had a number of these sorts of developments at committee over the time that I've been on the committee. They are often difficult, and it is often regrettable to see areas of land infilled within residential areas. Unfortunately, we do have a massive shortage of housing in York. Until we start to get on with some of the big developments that will deliver the housing need for the city, we will continue to get these kind of applications. But our job here is to apply the legislation and to protect ourselves from appeals. I think if we refuse this, it would certainly be turned over on appeal, because the NPPF is so clear in this regard. So the issue here is around the demolition of the one half of a bungalow, and it is a bizarre and strange situation that you can find yourself in, whereby somebody can apply to knock down half of the building that you live in. I don't think, I think we all feel that. But in terms of planning grounds, I don't see anything within the planning legislation that allows us to refuse it for that. There's the Party Wall Act as a piece of legislation which is designed to deal with this. We've heard the agent for the applicant, or the applicant themselves, I forget which they were, but did say very clearly that if the boundary needed to be adjusted to take account of a widening of the internal wall to make it meet building regs, there's an external wall that they were committed to doing so. And I don't see that there's anything further that we can do as a committee to protect the residents at number 47, other than state in very clear terms that if this does go ahead, we expect that the developer does all that's in their powers to ensure that it is done appropriately and doesn't damage the amenity of the pre-existing resident. But beyond that, I think we're going to hide into nothing to do anything other than to approve this.
Thank you. Is there any further debate? Councillor de Gaulle.
Yes, I think reference paragraph 5.34. I do note the concerns about the loss of trees prior to the application, and I do think, I mean, sadly, it's all too frequent the case that developers take action to remove trees that are inconveniently located before they put the planning application in, which is despicable, but that's the way of the world, unfortunately. I do, however, think that it also highlights the importance of for measures that are recommended to try and protect the root protection zone for those that are to be retained. And certainly from the developer's point of view, those trees are going to be a significant amenity value for the future residents. So it does make economic sense for them to do what they can to ensure that those routes are protected and the trees that are to be retained are safeguarded in that way. So that would be my main concern. I obviously share the other concerns about the party wall, but we've already rehearsed those arguments.
Thank you. Councillor Fisher.
Thank you, Chair. This is a sort of development I spent 9 years at my previous authority trying to stop. In those days, you couldn't stop it because backland development, it was then known, wasn't considered to be appropriate in most cases. Unfortunately, the law changed and now backland development is much more acceptable. I think the site is far too narrow, really, for what's been proposed. I think the presence of the houses is too close. I think the highway in particular is too close to the trees. But at the end of the day, I think it falls just within the limits of what is tolerable as far as those trees are concerned. I certainly won't be supporting the application, but I just cannot think of a good reason to refuse it that would stand upon appeal. But I'm not supporting it because I think it's a poor development. It's too cramped. The houses are too close to the southern boundary with no rear amenity space. I've never come across a situation where you demolish half of a semi. I've dealt with lots of demolitions in the past. In fact, 31 Lea Way is a much better example of, it's a much better scheme in every single way because it has a proper highway because they demolished the whole house and it was a much larger area of land. This is cramped, it's awful, but I can't think of a reason that would stand for appeal to refuse it.
Okay, thank you. Are there any further comments people would like to make? No, I can't see any. For my part, I associate myself with the comments of Councillor Webb and Councillor Crawshaw. I think a further hesitancy on my part is if I can see that if the land itself is being looked at again at the moment in terms of the green belt, I think you'd have a very strong argument for including it. There doesn't appear to be much to delineate that area of land from the rest of the land to the south, but similarly to the other issues that have been raised, it's not one I don't think that would stand up at the moment because clearly it isn't in the green belt at the moment. But in a way, it's a shame that this has come forward sooner than the consultation is finished, but we are where we are. But if there are no further comments at this point, I'm happy to move to the vote. And Gareth, if you're able to.
Thank you, Chair. So it's been moved to approve, subject to the conditions in the report as updated by the conditions, the three new and amended conditions and the informative in the update.
Thank you. Can't see any dissent to that, so if we're able then to move to the vote, and if I could see all those in favour of approving the scheme in line with what Gareth's just said, if you could just indicate now. All those against? Any abstentions? Okay, thank you, that is approved. That then is the only application we've got on our agenda today. So at that point, I'll close the meeting, and the customary sort of thanks to all the members and officers that have made this possible today. Know how much we all appreciate the extra steps that have been taken at the moment. Thank you.